In 2013, former Dean of the University of Belize, Abigail McKay, filed a claim in the courts suing the university, its president, provost, and the human resource director. McKay's contract was not renewed or extended, but she insisted that the UB's faculty and staff handbook provided for her contract to be extended by at least 2 years. She claims that the university's Board of Trustees unlawfully rejected this notion. McKay first sought the court's permission for judicial review on that matter, which was granted by Justice Courtney Abel. The case was taken all the way to the Court of Appeal, which today overturned Justice Abel's ruling. Senior counsel Dennis Barrow represented the University of Belize.
The decision which was reversed was that the claimant could have brought or carried forward a claim for judicial review, which is to challenge the decision which she says the university made. Our argument was that the university did not make any decision, and the Court of Appeal in effect upheld that there was not any decision made by the university to terminate or to do anything. She signed for a 3-year contract, and that was the end of it. If she had a right or had any basis for claiming that they ought to have given her a performance review, etc., that was a claim in contract and not a claim for judicial review. We took the point, the university took the point in the High Court that that was a wrong claim to bring, that she had a contract for 3 years. If she was dissatisfied with that, she should not have made a 3-year contract. She insisted that she had a right, although the contract doesn't say so, to a 2-year extension. Unfortunately, the judge, he went out of his way, as the Court of Appeal found, to try to help her along. But it was an erroneous move that the judge made. So the Court of Appeal has struck down the decision and said that the claim ought never to have been brought in this fashion.
Attorney for McKay, Audrey Matura-Shepherd, told reporters that she has to consult her client, who has to decide whether or not she wants to proceed with the matter.
It's a very important case, not only for my client, but for what it means. While the panel of judges have reserved their decision until a further date, the implications of it are several. One, they're saying that the decision would have been best grounded in contract. I mean, the application would have been best grounded in contract. But two, it brings into question now the fact as to the validity of the staff and faculty handbook of the university, which is what many of the people rely on, because they're saying basically it has no force. It has never been brought in by statute. Although I try to argue that there are cases that show that not everything is by statute, that there are legitimate expectations. Clearly, if you were in there, you were seeing that the judge, especially Justice Blackman, was absolutely not for it. He made a clear-cut distinction between the contract and judicial review. So at the end of the day, they're not saying that she doesn't have a claim. They're just saying don't bring it in public law, which is judicial review. Bring it in private law, which is contract. In reality, the contract did stipulate that she was entitled to an additional 2 years. She grounded that on the fact that it was, by the policy, it was a mandatory 5-year that deans should have. And so this should be a warning to all deans out there, anybody who gets hired by the university, to go and read the handbook and make sure that they incorporate the provisions of the handbook in their contract, so that, or to get better provisions than what is in the handbook. In terms of whether she would want to pursue further, well, that's a matter where we as attorney get instruction from the clients.
The Court of Appeal will hand down its judgment in writing on a later date.